The National Assembly is due to vote tomorrow on the new Electoral Bill that will see huge changes to our electoral system. For the first time, it would allow independent candidates to stand for elections in Parliament. In other words, it would allow an individual to stand for a seat in Parliament and in the provincial legislature. But the bill's also been hugely criticised. It treats, as I understand it, an entire province as a single constituency, and it would be much harder to stand as an individual candidate than as a political party. Lawson Naidoo is the Executive Director of the Council for the Advancement of the South African Constitution. Lawson, good afternoon to you. As I understand it, you oppose this bill. You believe Parliament should not pass it. Why do you believe that?
Good afternoon, Stephen. Thank you. This is an incredibly important bill. It strikes at the very heart of our democracy. It deals with the issue of the right to vote, which was the foundation of the struggle for liberation for one person, one vote of equal value. This is a piece of legislation that appears to have been cobbled together without very much thought. It flows from a judgment of the Constitutional Court, which held that provision needs to be made for independent candidates to contest national and provincial elections, as they do at a local government level, where independent candidates are able to contest wards. So instead of replicating the electoral model that we have at a local government level, the Minister of Home Affairs and Parliament seems to have concurred that this system that has been devised, which is basically the current party list system, which merely allows independent candidates to contest within those parameters. And as you point out, that means that independent candidates will be contesting the whole province as a constituency against established political parties. Whereas in CASAC's view and the view of many other civil society organizations, including the Minister's own advisory committee, that a mixed constituency and PR list system would be more appropriate. It would be fairer to independent candidates, and it would certainly enhance the levels of accountability in our democracy.
Can this bill be changed to make it work, or do you want the whole thing chucked out?
Well, I think we're on the cusp of a crisis, because we've got literally 18 months until the next elections in 2024. The IEC has told Parliament way back in August 2020 that they need to move with speed in order to finalize the new system, so that the Electoral Commission can adapt its mechanisms and its systems to be able to deliver an election then. So we're in a position now where we are probably going to have to tweak the current bill to remove some of its more onerous provisions, to try and make it fairer for independent candidates. But it cannot be a system that is bedded down for the long term in South Africa. It is an electoral system that does not exist anywhere else in the world, and it's probably for very good reason, because it is totally unworkable to accommodate the interests of independent candidates and to ensure fairness. So if it does pass tomorrow and does get amended further when it goes to the National Council of Provinces, it will hopefully be a piece of legislation and would, in a historical footnote, be referred to as an aberration that this was the only election conducted under this malign system, and that we have an opportunity for a public dialogue about meaningful electoral reform. This is an issue that is far too important to be left to political parties. It is a matter in which the electorate needs to be integrally involved.
Lawson, this all comes from the Constitutional Court ruling, which said Parliament must change the law to allow individuals to stand as candidates for Parliament. The court was basically ordering people who represent political parties to introduce more competition for those parties. Let me be the cynical one. It was deliberate, wasn't it? They're making it difficult deliberately.
No, absolutely. And, people have referred to this bill as an act of malicious compliance, and I don't think that's far from the truth. But whilst this piece of legislation that we're discussing does emanate from that Constitutional Court judgment, we must go back a lot further and recognize the party-list system that we have in place at the moment, which has now been declared unconstitutional, was implemented in 1994 because of its simplicity and the fact that it did not require a voter's roll in order to hold an election in 94. But the drafters of our constitution saw fit to say that this was going to be a temporary mechanism and that we should review the electoral system in due course. We then had the Fensel-Slabbert report in 2003. We had an independent panel assessment of Parliament in 2009. Former President Motlante's high-level panel review in 2017. And just a couple of months ago, the report from Chief Justice Zondo at the State Capture Commission, all of whom have said exactly the same thing, that we need to change the electoral system towards a constituency model to enhance the accountability of our elected representatives. Political parties don't want this. They have therefore shunned it and really, relegated the interests of the electorate. And that's why we believe that a vocal opposition to this bill needs to be mounted. There are members of Parliament who don't actually understand what is in this bill, and yet they're going to be asked to vote on it tomorrow because it is a highly complex bill with a mathematical formula for calculation of seats that even mathematicians disagree about.
Lawson Naidoo, thank you, the Executive Director at CASAC. Do appreciate the time.